from members of the applicant in such state or federal state branch council. For a declaration that the applicant is entitled to proper and accurate account from all her state, federal branch council of all funds, monies received on her behalf from members of the applicant in such state or federal state branch or council. 5, a declaration that the applicant is empowered by the extant laws and her constitution to ensure that all funds of monies deducted as check-off dues of her members, the respective state or federal branch council, is properly and accurately appropriated as specified in Rule 30, paragraph 1, subparagraph C of her constitution as registered with the Registrar of Trade Union. 6, an order compelling and/or directing the first respondent to remit any shortfall of money remitted as check-off dues from members of the claimant to the National State Branch Council by employers of applicant members in National State. And 7 is an omnibus prayer. The grounds upon which this application is predicated is as follows. 1, A, the applicant by her constitution and the Trade Unions Act is enjoined to take check-off dues from her members. And she has members in Nassau State Council, but there has been no proper account of the money received by the first defendant since 2016 to the claimant. And B, the respondent refused or neglected to honor the invitation of the audit committee or avail the committee set up by the claimant for the purpose of ascertaining the correct financial standing of the Nassau State Council with the financial records of Nassau State chapter of the claimant. In support of the claimant's originating motion is a 13-paragraph affidavit deposed by one comrade Godwin J. Oshiekwe, and annexed to same are documents marked as Exhibit N1 to N3. I've reduced facts of his of his deposition into the body of this judgment. Also filed is a written address. I've reduced the facts, the arguments of counsel in the written address equally into the body of judgment. The second respondent in response filed a notice of preliminary objection dated 8th of September 2021, pursuant to Order 17, Rule 9 of the rules of this court, urging the court to strike out this suit against the second respondent for want of cause of action, and also asking the court to strike out the suit against the second respondent for want of jurisdiction and an omnibus prayer. The grounds upon which the application is predicated are 1, that the dispute between the parties in the substantive suit relates to administration of the affairs of the plaintiff, a registered trade union, that the second respondent is not a member of the plaintiff. 3, that the second respondent is not a necessary party to the substantive suit. 4, that the plaintiff's suit as presently constituted did not disclose a reasonable cause of action against the second respondent. 5, that the jurisdiction of the court cannot be invoked against the second respondent in the absence of a reasonable cause of action. 6, that the Honorable Court has jurisdiction to strike out any suit which does not disclose a reasonable cause of action against the defendant. And 7, that it will be in the interest of justice to grant the application. Accompanying the notice of preliminary objection is written address, and counsel framed the sole issue, reduced that into the body of this judgment. Learned counsel for the respondent equally filed a counter affidavit. I've reduced that into the body of the judgment. The first respondent, in opposition to the originating motion, filed a 27-paragraph counter affidavit deposed by one comrade Jacob Kaura Makama. The annex to that 7 exhibit marked as exhibit A1 to A4, B1 to B3. I have reduced all the facts into the body of the judgment. They also filed written address wherein 3 issues were framed, and arguments in support of that have equally been reduced into the body of this judgment. Claimants replied to the first defendant's notice of preliminary objection, and both respondents' addresses. I've reduced that also into the body of this judgment. So let me go straight to the decision of the court. Let me at this stage indicate that I will consider the objections raised by the first respondent in the final written address to the jurisdiction of this court to entertain and the notice of preliminary objection to the jurisdiction of this court to entertain this case, the notice of preliminary objection filed by the second respondent on the absence of cause of action against the second respondent. Subsequently, I will explain my reason for adopting this procedure in the decision part. I'm mindful of the point raised in paragraph 1.2 of the reply and point of law in opposition to the first respondent counter affidavit that the first respondent does not have a written address before this court, as the written address attached to the counter affidavit of the first respondent was signed by one Megbele Nkasiobi Esquire of Emeka Wogu and Company, second defendant's counsel. The said written address was attached to the counter affidavit of the first respondent. It is also clear on the face of the said process that it was franked by Megbele Nkasiobi Esquire, who has since the inception of this matter, as evinced by the record of this court, been appearing on behalf of the first respondent, and even today, it is thus clear that the inscription of the second defendant's counsel beneath his name is mere typographical error. More so, one of the addresses for service on the said process is the address of the counsel of the second respondent. There's therefore no doubt that the description of learned counsel on the said written address was merely a mistake, which I'm very sure learned counsel for the applicant is aware of, because he knows the counsel who has been representing the respondent in this case, who is also here in this court today. Learned counsel for the applicant, Anthony Tejere Esquire, merely want this court to dance to the tune of rigid technicality. This court will take such a dancing step as this court will not take such a dancing step, as doing so will occasion miscarriage of justice to the parties and to the cause of justice.
As the court pleases.
I find that the written address dated the 3rd of December 2021 filed along with the counter affidavit of the first respondent is that of the first respondent. I so find and hold. I will now proceed to explain why I adopted the procedure of considering the objections first. This action was commenced by an originating motion supported with an affidavit stating the facts upon which the applicant is relying on written address. It is without doubt. The originating summons and originating motions are similar in nature in that they are both decided based on affidavit evidence, which is of the status of statement of claim. See the case of D's Oil and Gas Limited versus SNG Limited citation captured. It is tried that one of the objectives of originating summons or motion process, as the case may be, is that proceeding initiated thereby are very expeditiously dealt with. See the case of team versus PDP and others citation captured. Thus, it is clear that the procedure adopted in the two procedures are the same, and any procedure applicable in one will be applicable to the other. The courts have held that an originating summons and the notice of preliminary objection on jurisdiction can be taken together, provided the court determines the objection first before proceeding to address the merits of the case. See the following cases: General Muhammad A. Garba, retired, versus Mustafa Sani Muhammad and others citation captured. The case of Yaradua and others versus Yandoma and others citation provided. The case of Dapiolong and others versus Darie and another citation captured. In restating the principle of law, when a challenge to the jurisdiction of the court is raised in an action commenced by originating summons, the Supreme Court per Mohammed JSC in the case of AG Lagos State and others versus AG of the Federation and others citation captured held those that I quote. When a preliminary objection is raised in actions such as the present one commenced by originating summons, it is always better to take the preliminary objection with the substantive that if the objection to the action succeeds, the case or action is terminated in limine. If the objection fails, however, then the court will proceed to determine the substantive action on its merit, unquote. In view of the point reasoned supra, that the procedure applicable in either of the originating summons or originating motion will be applicable to the other, it then means that an action commenced by originating motion may as well be taken together with preliminary objection. Thus, this court can take the preliminary objection together with the substantive action in this suit. I so find and hold.
As the court
In the
pleases.
instant case, the argument of the first respondent as contained in the written address in support of this, its counter affidavit to the originating motion is that this action is prematurely before this court as the conditions precedent as provided in the constitution of the applicant has not been complied with, that the applicant has no local standing to institute this suit, and that the originating process is not competent because it was signed by an unknown person. Put differently, the court's jurisdiction in this case has not been properly activated by the applicant in this case, and the applicant equally does not have local standing to institute this action. I am mindful of the objection raised by applicant to the competence of the said process of the first respondent, that the said process, which includes the address together with memorandum of appearance, were filed out of time, and that no application for extension of time is before the court. He equally submitted that by Order 17, Rules 1, Sub-Rule 10 of the rules of this court, the second respondent applicant has 7 days to file a counter affidavit and written address to the motion served on it. Let me point out to learned counsel for the applicant, Mr. Itejere, that the whole of Order 17 of the rules of this court deals with motions and other interlocutory applications. In essence, Order 17, which learned counsel is relying on, deals with interlocutory applications, whether by way of motion or other interlocutory applications which are made during the pendency of an action. This is clearly distinguishable from an originating motion, which is an originating process in this case. One of the ways of commencing action is by an originating motion before this court. See the case of Alpha and Atai citation capture, the case of Nigeria Cement Company Limited versus NRC citation equally captured. Order 3, Rule 1 of the rules of this court. It is worthy of note that there's a world of differences between an originating process like originating motions in this case, and an interlocutory process like motion or notice, to which Rule 17 of the rules of this court applies. An interlocutory process, which is usually by way of a motion, is always provisional, interim, temporary, and intervening pending the determination, while the originating process is the one commencing an action. See the case of IFC versus DSNL Offshore Limited citation captured. Thus, the originating motion in this case, being an originating process, is to be responded to within the period provided in the rules of this court for responding to originating process. Order 9, Rule 1, Sub-Rule 1 of the Civil Procedure Rules of this court provides thus, and I quote, "Every person served with an originating process shall within the time stipulated therein, and if no time is stipulated, shall within 14 days of the service of the originating process file a memorandum of appearance in the registry of the court," unquote. In the same vein, Order 15, Rule 1 of the rules of this court provides that where a party is served with an originating process and he intends to defend or counterclaim, he shall not later than 14 days or the time prescribed for the defense file his defense. The originating motion in this case has no time stipulated on it, and thus going by Order 9, Rule 1 and Order 15, Rule 1, respectively, appearance the same, and counter affidavit is to be filed within 14 days. The memorandum of appearance filed on behalf of the first respondent was filed on the 16th of June, 2021, which was clearly out of time. That notwithstanding, it must be noted that Order 5, Rule 1 of the rules of this court, which provides, thus I quote, "Failure to comply with any of the rules of this court may be treated as an irregularity and the court may give any direction as it thinks fit," unquote. There's no doubt, going by the said provision, that the court may treat the failure on the part of the first respondent to file within the stipulated time as an irregularity, and go ahead to consider the said process, which raises substantial issues as to the jurisdiction of this court. In view of the foregoing, the objection of learned counsel for the applicant Itejere Esquire to the processes filed by the first respondent is thus discountenanced. The objection raised in the notice of primary objection of the second respondent is that the claimant does not have any cause of action against it, and as such, the court does not have jurisdiction over it. It must be noted that if this court decides that its jurisdiction has not been activated as contended by the first respondent, and as such declines jurisdiction, or that the applicant has no legal standing to institute this action, then there will be no vials to determine whether the case of the applicant discloses any reasonable cause of action against the second respondent, which is the bane of the notice of preliminary objection, talk less of considering the merits of the originating summons. Accordingly, I'll consider the objection raised by the first respondent as contained in the written address first, before I consider the notice of preliminary objection on the merit of the originating motion, if there will be any need. In resolving the objection raised as to the jurisdiction of this court as raised by the first respondent in this address, I will address the issue of the competence of the originating process first, because it is only when the originating process is competent before the court first that the court will have the vials to look at the other issues raised as I've stated earlier. Learned counsel for the first respondent, Megbele, has in paragraph 5.0 of the written address submitted that the originating motion is not competent because it was signed by an unknown person, as the name as enrolled at the Supreme Court is SCN 046903, is one Anthony O. Itejere and not Anthony Itejere Esquire, who signed the originating process. As such, the name Anthony Itejere is unknown and unacceptable in law. It is tried that when an originating process is incompetent, nothing can be done to validate it. The Court of Appeal in the case of Diamond Bank versus Tranta International Limited and another citation captured, while relying on the decision of the court in the case of Olagbe and others versus Alaiwola and other citation captured, held that is now settled principle of law. A court is only competent to adjudicate over a matter when all the conditions precedent for its having jurisdiction have been satisfied. Thus, an action began by an incompetent process would divest the court of jurisdiction to entertain the matter. The rules of this court, specifically on the 6th rules, Rule 1, Sub 2 of the Rules of this Court 2017 provides that each copy of the originating process shall be signed by the claimant suing in person or by the counsel otherwise, and shall be certified after verification by the registrar of court as being a true copy of the original process filed. Thus, every originating process shall be signed by either a claimant or his counsel. The pertinent question that should be asked at this stage in respect of the objection is whether the fact that Anthony Itejere Esquire signed the originating process makes same incompetent. In addressing this question, I'll make copious reference to a recent authority of the Supreme Court. In the case of Indul versus Bayo citation capture, the Apex Court held that by virtue of Rule 10 sub Rule 1 of the Rules of Professional Conduct 2007, a lawyer acting in his capacity as a legal practitioner, legal officer, or advisor of any government department or ministry or any corporation shall not sign or file a legal document unless there is affixed on any such document a seal or stamp affixed by the Nigerian Bar Association. The court went further the court went further on page 69, paragraph F, and page 73, paragraph C, to state that legal documents for the purpose of Rule 10 above includes pleadings, affidavits, applications, and so on. It then means that the originating motion in this case falls within the purview of legal documents. It is worthy of note that the Supreme Court also held in the case of the same Indul and Wayo Supra at page 73, paragraph D, that a document purportedly signed by a legal practitioner without a seal and stamp will be deemed not to have been properly signed or filed. Conversely, it means that where legal document purported to be signed by a legal practitioner has affixed to it the approved seal and stamp of the NBA, same will be deemed to have been properly signed. The originating motion in this case was signed by Anthony Tejere, Esquire, as proceeded by learned counsel for the first respondent. The process equally has on it the stamp and seal of the Nigerian Bar Association NBA with the name Anthony O. Itejere, which purports to be the seal of Anthony Tejere Esquire, who signed the process. Following the decision in the case of Indul and Wayo Supra, I am of the view that the process was properly signed, as the seal and stamp of NBA on the process is a pointer to the fact that he is a legal practitioner qualified to practice, and the non-inclusion of the initial quote and unquote O is not fatal to the competence of the originating process. I've taken note of the Supreme Court case of Esenowo versus Ukpon Supra, relied upon by learned counsel for the first respondent, Mr. Ngbebele. I've read the said authority, and it is clear that the Supreme Court in that case was dealing with the change of initials by the appellant as medical doctor in that case. And the court held that there is a world of difference between J.E. Esonomo and E.J. Esonomo for the purpose of registering a name in a professional register sanctioned by law. Apart from the fact that the case is distinguishable from this one, in that the appellant in that case was a medical doctor and not a legal practitioner with the seal and stamp of that case. The Supreme Court in that case stated why that exchange of initials in that case should not be allowed. The court held further that such change of initials allows crooks and quacks to infiltrate into the profession if a random person can rearrange his initials or order in which his names are written. It is clear from that decision that the decision was informed by the need not to allow crooks and quacks infiltrate a profession in order for a professional to maintain his identity as preceded by the correct arrangement of initials. In my view, the rationale for the decision of the Supreme Court is the need to clarify the identity of who is referred to so as to prevent quacks and from taking advantage of it. It should be noted that the Apex Court, in a more recent case of Titilayo Plastics Industries Limited and others versus Fagbola, citation captured, while expatiating on its decision in Esonowo and Ukpon Supra, held further does, and I quote, in the absence of any averment or documentary evidence explaining the discrepancy between the two names, the court was right to hold that this discrepancy is a fundamental defect and not a mere misnomer. For instance, where father and son bear the same names and or initials, the only means of differentiating between them is by an additional name or a middle name or by affixing quote and unquote junior, meaning junior after the names. It is not for the court to speculate without evidence, unquote. That means that where there is a documentary evidence or any means of explaining the discrepancy in the name, such failure to state the name correctly will be a mere misnomer. The originating process in this case has affixed to it the NBA seal and stamp showing the enrollment number of the legal practitioner who signed the process. Lawyers do not have the same enrollment numbers. Even if there was another Anthony Tejere on the roll of the Supreme Court, the enrollment number of the seal of the NBA has clearly distinguished him from any other Anthony Tejere. Hence, failure to put his initial, quote and unquote, 0 or O while signing is not fatal, as the seal clearly shows by whom the originating process was signed, and the affixation of the NBA seal showing his enrollment number is a pointer to the fact that the person who signed as Anthony Tejere Esquire is the same person qualified to practice as legal practitioner in Nigeria. Accordingly, this court finds that the originating motion has complied with the provision of Rule 10, Sub-Rule 1 of the Rules of Professional Conduct and Order 6, Rule 1, Sub-Rule 2 of the Civil Procedure Rules of this court, and thus competent, I so find and hold.
As the court pleases.
Again,
As the court pleases.
I'm not conceding that the said originating motion is not even competent because it was neither signed by the applicant itself or by a non-legal practitioner as proceeded in paragraph 5.0 of the address in support of the counter affidavit of the first respondent, which is clearly in breach of the 6 Rule 1, sub Rule 2 of the rules of this court. Can the originating process be said to be incompetent for that reason? By the provision of the 5 Rule 1 of the rules of this court, the originating process cannot be said to be incompetent, as the same may be taken as a mere irregularity. The court, in the case of Unity Capital Insurance, Assurance versus Uzoku, citation captured, per Agim JCA, who held thus in respect of the effect of non-compliance with the 6 Rule 1, sub Rule 2 of the rules of this court in the practice and procedure of signing court processes. I quote him, in the light of the 5 Rule 1, it cannot be validly contended that the failure to comply with the 6 Rule 1, sub Rule 2 renders the writ incompetent, and the argument that the trial court was therefore wrong to assume jurisdiction to try the suit is not valid. In view of the clear provisions of the 5 Rule 1 of the NICN Civil Procedure, I hold that the decision of this court in Ofodu and others versus Aniagolu and others delivered on the 30th of June 2016 in CS/E/477/2014 cited as a ground for this application is per incuriam and therefore is hereby departed from judicial decisions that restate the general principle that an unsigned process is void, cannot apply to a writ or complaint not signed as required by Order 6 Rule 1, sub Rule 2, because of NICN Civil Procedure Rules 2017 prescribe clearly that the non-compliance can be treated as an irregularity, unquote. Honorable Justice Agim, in that decision, had cause to pronounce on our Order 5 and Order 6 as well. On the above case, relying on the above case, assuming the said originating process was not even signed by a lawyer in clear breach of the 6 Rule 1 sub 2, same is to be regarded as a mere irregularity. In view of the above reasoning and all stated herein before, the objection raised by the first respondent as to the non-competence of the originating process therefore resolved in favor of the applicant. Now to the objection on local standing, which is challenging the capacity of the claimant to institute this action in court against the defendant, goes to affect the jurisdiction of the court before which such action is instituted. Where there is no local standing, the court cannot assume jurisdiction to entertain the action at all, not to talk of considering if the court's jurisdiction has been properly activated in view of the provision of Rule 38 of the Constitution of the applicant. See the case of Amos and others versus Okoya and other citation captured. The case of Registered Trustees of Masters versus Ministries Nigeria Incorporated versus Emenike and other citation captured. The case of Ajayi and Adebisi and 3 others citation also captured. This is because without local standing, the applicant has no local standing to bring a suit. The suit becomes incompetent and the court lacks the jurisdiction to entertain it. The only order the court can make in the circumstance would be that of dismissal. So the case of Achonya and order versus Eze and another citation captured. Local standing being an issue of jurisdiction can be raised at any stage or level of the proceeding in the suit, even on appeal at the Court of Appeal by any of the parties without leave of court or by the court itself so motu. Thus, it could be raised even in the address as is done in this instance. In the case of Inyosom and Peter's side, the Yepes Court per Kekeria Kujesi held amongst others that in order to determine whether a party has local standing, what should be considered is the pleadings, which in this case is the affidavit in support of the originating motion, that will be considered by the court, and the claimant must show sufficient interest in the subject matter of the suit. See also the case of Edna and Governor of Delta State of Nigeria, order citation captured. In essence, where the claimant or applicant discloses sufficient interest in the subject matter of the suit, it is entitled to sue. In other words, the claimant or applicant must be able to show that its personal interest will be affected or adversely affected by the subject matter of the suit. The pertinent question to answer now is, has the applicant disclosed sufficient interest in the subject matter of this action, which is to render account of the check-off dues collected under the administration of the first respondent? No doubt, the applicant in this case, as evinced by the affidavit in support of the originating motion, is a registered trade union to which payment of check-off dues deducted from its members is due. Section 17, subparagraphs A and B of the Trade Unions Act, Cap T 14, provides that every employer shall make deductions from the wages of every worker who is a member of a trade union, and same shall be remitted to the registered office of the trade union within a reasonable time or within the time prescribed. The applicant, no doubt by the affidavit, is entitled to the remittance of the deduction of the check-off dues as provided for in its constitution. There is no gainsaying that the applicant is seeking that the respondent render an account of the check-off dues to members in Nasarawa State Chapter under the administration of the first respondent. I am of the humble view that the applicant as the union to which the check-off dues are to be paid has sufficient interest in the subject matter of this action, which is to render account of the check-off dues collected from its members. The applicant, by its affidavit in support of the originating process, has been able to show that its pecuniary interest has been adversely affected by the acts of the respondent, which gave rise to the subject matter of this dispute. In view of the foregoing, I'm of the unwavering view that the applicant has the requisite locus to institute this action. I so find and hold. Now to the issue of non-compliance with the procedures provided in Rule 33 of the Constitution of the applicant. Learned Counsel, on behalf of the applicant in this case, has submitted by paragraph 3.04 of the reply and point of law that Rule 38 of the Constitution of the applicant is not applicable in the circumstance of this case, as the said provision is made applicable to members of the union and has no bearing with the power of the union to take action against a member of the union. For the purpose of clarity, I will reproduce verbatim the provisions of Rule 38 of the Constitution of the applicant, which is part of the evidence before this court, and it stipulates thus, I quote, A, in the event of occurrence of intra-union dispute, in the union dispute shall be referred to the unit executive for the resolution within 21 working days. In the first instance, if the matter cannot be resolved, the unit shall report the dispute in writing to the State or Federal Council Executive. And where the State or Federal Council Executive fails to resolve the dispute within another 21 working days, the State or Federal Council shall report the dispute in writing to the General Secretary. B, the General Secretary shall, after discussing with the National President, shall within 30 days of being notified of the dispute, attempt to reconcile the aggrieved parties. C, if this fails, the General Secretary shall refer the matter to the next meeting of the National Administrative Council Central Working Committee, CWC, for necessary action. D, if the National Administrative Council and the Central Working Committee are unable to resolve the matter, shall be referred to the National Executive Council for final resolution. And E, for the avoidance of doubt, no member, state, or federal council unit shall employ other processes, including court litigation, to resolve any intra-union dispute in the union without exhausting the laid down procedure enumerated in this rule, unquote. The above provision of the rule is clear and admits no ambiguity. It is now settled that where the words of a contract, agreement, or document are clear, the operative words in each should be given their simple and ordinary grammatical meaning. See the following cases: Haramwa and People's Bank of Nigeria Limited and another citation captured, Urara Securities and Finance Limited versus TIC Limited citation provided. The above provision is to the effect that in the event of intra-union dispute, the laid down procedure must be followed. Section 54 of the National Industrial Court Act 2006, hereafter referred to as NICA, defines intra-union dispute as, quote, Intra-union dispute means dispute within a trade union or an employers association, unquote. More emphatically, the appellate court per Ikenbe, JCA of blessed memory, in the case of Kalango versus Dokubo, citation provided, define an intra-union dispute as, and I quote, such dispute is an intra-union dispute if it is between members of a union on one hand and the union itself on the other, or if it is between or among members of the same union inter se, unquote. See also the case of Umoren versus Ackman and other citation captured. It is worthy of note that the above definitions receive approval in the more recent decision of the Court of Appeal in the case of Nasu versus Jacob A and others citation captured. In essence, an intra-union dispute is any dispute within a trade union, whether amongst its members or between the union and its members, provided it is within the union and does not extend to another union. This clearly means that the dispute on this case, which is between the union as the claimant and the first respondent, is intra-union dispute. Find that the mere presence or joinder of the second respondent will not operate to divest the dispute, in this case, of the nature of an intra-union dispute, as the dispute is majorly between the union and the first respondent, who is its member. Obviously, learned counsel for the applicant misconceived the import of Rule 38 of the Constitution of the applicant when he submitted that the rule only applies or envisages or applies to dispute between members of the union. If I may ask, can members of the union exist without the union itself? My firm view is that members exist because there is a union. Both the union and members are like Siamese twins, which cannot be separated. The rule specifically provides for procedure to be followed in the event of intra-union dispute, where this court, as reason supra has held, to include dispute between the union on one hand and its member or members on the other hand. It then means that if the dispute in this case is intra-union dispute, the provision of Rule 38 of the Constitution of the applicant must of necessity be followed, as it is mandatory. As a corollary to the above, let me point out that the procedures provided in Rule 38 is to the effect that the court cannot be a first point of call in respect of intra-union dispute. In other words, parties must comply with the internal dispute resolution mechanism prescribed in their constitution before approaching this court. It is pertinent at this stage to also state that the provisions of Part 1 of the Trade Dispute Act, Cap 432, Laws of the Federation of Nigeria, 2004, hereafter referred to as TDA, provides for the procedures to be followed before a trade dispute can be resolved. The process provided in Part 1 of TDA are processes as to conciliation and arbitration. Thus, the parties must have gone through conciliation and arbitration before the appellant or before the parties, before the appellate jurisdiction of this court can be invoked. It should be noted that the dichotomy created before on the application of the procedures in Part 1 of TDA as regards inter and intra-union dispute has been breached by Decree 47, which is now an act of 1992, which amended the TDA to include intra and inter-union disputes. From the provisions of the said Part 1 of TDA, it is clear that the court, especially the NICN, cannot be the first point of call in the trade dispute. Parties must have gone through the process of arbitration and conciliation before approaching this court. It is equally worthy of note that NICA equally provides in Section 7, subsection 3, that notwithstanding anything contained in the Act, nothing shall preclude the National Assembly from making a law providing that a matter must go through conciliation and arbitration before coming to this court. That the Trade Dispute Act is an act of the National Assembly, which pursuant to Section 7, subsection 3 of NICA, prescribes in its Part 1 that trade dispute, including inter and intra-union dispute, must go through the process of conciliation or arbitration before such matter can be heard by this court as of right in appellate jurisdiction. This court has before now held that dispute in respect of refusal to deduct check-off dues can properly be heard under the dispute resolution mechanism under Part 1 of TDA. See the decision of this court in the case of Corporate Affairs Commission versus Amalgamated Union of Public Corporations Civil Service, Technical and Recreational Service Employees, citation captured. In the same vein, this court in the case of AUPCTRE versus FCD and others, citation captured, which was one of the cases relied on by the parties in their written briefs in the case of NASU versus Jacob and others, Supra, held inter alia that in appropriate cases, the original jurisdiction of this court may, by an act of National Assembly, be made contingent upon exhausting the process of conciliation or arbitration. Only recently, this court paid B.B. Kanyip, the Honorable, the President of this court, held inter alia in the case of Senior Staff Association of Statutory Corporations and Government-Owned Companies, SSA, SC, GOC versus Honorable Minister of Labor and others, is an unreported suit number NICS/ABJ/39/2021, judgment that was delivered on the 10th of March 2022, specifically in paragraph 86, reasoned that the only exception created to Part 1 of TDA, wherein a trade dispute matter can come to this court in its original jurisdiction, is in respect of a trade union election dispute, which are by nature urgent. His Lordship in that wise relied on Section 18 and 19A of NICA. In the same vein, the court in Nassau and Jacob and others, Supra, held us, and I quote, "The question now is whether the lower court had jurisdiction to hear and determine an intra-union dispute. The jurisdiction granted in the NIC by the Constitution and by statutory provision as found in NICA regarding trade disputes such as inter and intra-union dispute is an appellate jurisdiction exercisable after the said dispute have gone through the conciliatory and arbitration body. See in particular the provisions of Section 254C1J of the 1999 Constitution as amended and Section 7 subsection 4 of NICA. Therefore, I agree with the appellant's counsel that both the NICN and an inferior body such as an arbitration tribunal cannot have concurrent jurisdiction over trade disputes, including inter and intra-union disputes," unquote. The decision above is clear, and that is to the effect that this court jurisdiction in respect of trade dispute, whether intra-union or inter-union, is appellate and not original, as parties must have explored conciliation and arbitration process provided in Part 1 of the TDA before approaching this court. The position of the law stands firm to the effect that if a court has no jurisdiction to hear and determine a matter before it, then it cannot proceed to entertain same, as doing so will be an exercise in futility amounting to a nullity. This is captured in the Latin maxim "est nihilo nihil fit." There is no evidence of record to show that the applicant has explored the internal mechanism of the union and or Part 1 of the TDA before approaching this court. The appropriate order to make in the circumstance would be an order striking out the matter for want of jurisdiction. With the following cases: Musindi and others versus Achusi and others, citation captured. Case of Ehua versus Ondo State Independent Electoral Commission and other citation also provided. In view of all the reasoning, Supra, this court finds that it lacks jurisdiction to entertain this matter. It is for this reason, and as stated earlier in this judgment, that I will not go into issues raised in the notice of preliminary objection and the merits of the originating summons. This case is accordingly struck out. I so hold. Parties are to bear their respective costs. Judgment is accordingly entered.
As the court pleases.
As the court pleases. My Lord, may I especially thank you for the industry invested in this judgment just delivered. We appreciate it, particularly when the court is even on vacation, you still find time out of your other engagements to give us attention. Thank you so very much.
You're welcome. So you are entitled to clean copies, which you may pick up at the court anytime.
As the court pleases.
So we have come to the end of today's proceeding. I will rise.
As the court pleases.
As God pleases, my lord.